Breaking news out of the United States Supreme Court. As I've mentioned before, 37 amicus briefs have been submitted basically in favor of the government's position, although some of them say they're not supporting either party. But the reality is they're all basically for more gun control. What's interesting is some of the briefs are actually embracing laws at the time of our founding that had racist and odious and bigoted foundations upon which they rest. And nevertheless, some of the anti-gunners are embracing these. Of course, they're dropping footnotes to say we don't support the laws. Nevertheless, they think they're appropriate to be considered by the Supreme Court to take away our 21st century Second Amendment rights. Stay tuned. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the book, First They Came for the Gun Owners, the battle plan that the left intends to use to take away our gun rights from A to Z. I put it all together in a single book. Check out First They Came for the Gun Owners if you don't already own a copy. All right, folks. So, United States versus Rahimi, a major Second Amendment case. We've talked about this case before. We know that Mr. Rahimi, has allegedly a very bad past involving multiple shootings, hitting his girlfriend's head on the dashboard, I think is the allegation, or what was admitted, whatever you want to say. Nevertheless, obviously, this is a tough case from the perspective of the Second Amendment in certain respects, because he's not the kind of guy, I would guess, is the sort of person that people should be supporting with the right to keep and bear arms. So the issue here is we now are litigating whether or not 18 U.S.C. 922 G8, dealing with domestic violence orders, whether or not those are sufficient to take away people's right to keep and bear arms, whether those laws are consistent with the Second Amendment's right to keep and bear arms, and that is the issue presented. Of course, as you know, Merrick Garland and the Department of Justice rushed this case to the front of the line because they think it's going to put pressure on the quote-unquote middle of the court, Justice Kavanaugh, Justice Barrett, and Justice Roberts, to perhaps jettison the whole Bruin methodology, which has worked very well for the Second Amendment community over the last year or so. Certainly when you compare the number of Second Amendment wins in the last, since Bruin in summer of 2022, with the Second Amendment, the number of Second Amendment wins between 2008, the decision of Heller, and 2022, the decision of Bruin. Obviously, the Bruin methodology is, generally speaking, working for the Second Amendment community, which is why Merrick Garland hopes to gut the methodology, to gut that approach to the Second Amendment in the Rahimi case, because he's hoping the Supreme Court's going to bend over backwards to screw up the methodology, all to make sure this odious character, apparently, based on the record, this odious character, Rahimi, basically he basically loses. That's the idea, at least. So what's interesting, though, is we're starting to see these amicus briefs come in. There have been 37 of them. And what's interesting, the number of them that are embracing as historical analog laws to justify taking away our fundamental right to keep and bear arms. We're noticing how they are embracing laws that have racist, nativist, odious underpinnings or histories. For example, there's the laws that involving the Catholics, disarming Catholics, not selling guns to the Indians, the slave codes, and so on. It's very interesting how a lot of these sort of anti-gun, gun control supporters arguing that government has the right to do all sorts of things, or I should say the power. Individuals have rights, governments have powers, government have authority. What's interesting that is exactly what's going on here. Let me just give you a couple examples, and then we're going to talk about the significance here, because it's very important that you understand how to handle these. To begin with, there is a amicus brief submitted by the history and law professor's brief, and they specifically talk as historical analog laws. And just as a reminder, once the text of the Second Amendment is implicated, which undeniably is the case here, because under 18 U.S.C. 922G, Mr. Rahimi loses his gun rights during the time of the domestic violence order or the restraining order. So it clearly implicates the text of the Second Amendment, the right to keep and bear arms. So the question is, can government satisfy its burden? Because once the text is implicated by a modern-day gun control law, the burden shifts to the government to come forth with historical analog laws, not general airy-fairy history, mind you, specific laws on the books to justify the modern-day gun control law to demonstrate it's part of a long-standing tradition of American gun laws. For example, the example I always like to give is murder is an example where you couldn't use a gun to commit murder at the time of the founding. You couldn't use a gun to commit murder during the 19th century or the 20th century and now the 21st century. That's the kind of long-standing firearms regulation or tradition that the court is looking for to justify a modern-day gun control law. So if you are indicted for murder using a firearm today, you can't assert a Second Amendment right because that was never allowed, including at the time of the founding. That's what the court is looking for. And if you don't see something like that, when in doubt, throw it out. The gun control law should be tossed out. So what's going on here, of course, is there are very few gun control laws at the time of the founding. That's the way it should be because Americans were free. The Bill of Rights was about freedom. That was the whole idea. Nevertheless, you see briefs, for example, by this group of history and law professors are literally talking about the disarmament of blacks, Catholics, and Native Americans, or as Justice Kennedy said in the Heller oral argument, the Indians. Again, the purpose of these laws is to say at the time of the founding you had gun control laws dealing with these individuals, these groups that were perceived to be dangerous in some way or perceived to be a threat to the social order, and therefore we can disarm them based upon these 18th century precedents. We can disarm people we consider to be dangerous today, and that is basically how the argument is flowing out of these amicus briefs. So let me tell you exactly what this brief says. In the history and law professor brief says the following, quote, "Many states also disarmed individuals based on specific religions, political views, ethnicities, or other categories perceived by the state governments at the time as threatening the public order. Some of these laws prohibited selling arms to American Indians and those from outside of the jurisdiction. Other laws targeted Catholics. Still other laws targeted slaves and freed black people. Even pacifist groups, such as the Quakers, were disarmed due to their refusal to pay taxes and the perception that they therefore threatened the social order. These restrictions, according to this brief, quote, again, we're continuing the quote here, these restrictions undermine any historical view that the right to bear arms precluded the ability of the state to protect society against individuals perceived as dangerous and preserve social order, period, close quote. That word perceived is very interesting. I suspect there's many left-wing Americans living in urban areas in blue cities such as New York, Boston, Chicago, Los Angeles, California, and the like that probably perceive supporters of President Trump or perceive conservatives or perceive supporters of the Second Amendment to be dangerous. So you can see how they're trying to use the word perceived to sort of justify disarming people that are perceived to be dangerous as opposed to perhaps actual threats. But let's set that issue aside. It's very interesting that the lawyers and those professors, they admit in their brief that these laws were motivated largely by things that would be considered repugnant today. Nevertheless, they say it still rests on the principle of dangerousness as their precedent. So that is the kind of thing that we're seeing. We're seeing actually gun control supporters embracing these laws that have these noxious or these odious underpinnings. A lot of them are racist, anti-Catholic sentiment, which is kind of interesting because, as you know, there are several Catholics on the U.S. Supreme Court right now, including Justice Barrett, Justice Roberts, and so on. I only mention that because it's interesting that here you have people quoting to the United States Supreme Court with several Catholics on the court, laws that say you could disarm Catholics at the time of the founding. One wonders how that's going to fly, but it is a little bit of an irony there. We'll see what happens. That's not the only brief that was submitted in support of the gun control view or the expansive view of government control over guns. Some organization called the 97% Group. I'll put links to these briefs down before you can check it out for yourself, see if I'm telling the truth and got it right. Again, the 97% Group talked about slaves and Native Americans. This is their quote. They said, quote, "Thus it is no surprise that throughout American history, groups of people have been prevented from purchasing and possessing firearms based on perceptions of dangerousness is what they argue. They then go on to actually cite to Justice Barrett in her dissent in Cantor versus Barr, which I talked a lot about on Fox News, if you recall those days where I was discussing the importance of then Judge, now Justice Barrett, to get on the Supreme Court. Again, discussing sort of her background, Cantor versus Barr, which was a decision involving nonviolent felons, where she dissented in favor of the Second Amendment. I thought was a major factor that allowed her to get on the court, because it showed that she had a committed view of the Second Amendment right to keep and bear arms, which is very important. Again, the brief submitted by the 97 percenters, or whatever they're called, the 97% group, they also said that these race-based laws involving Native Americans or slaves, they're disgraceful, but they also say, again, the historical takeaway is clear. Founding era legislators categorically disarmed groups they considered to be a threat. Again, you see this sort of wholesale disarmament. And again, just as a step back for a second, there's two ways to disarm Americans, as I see it, and I write about this in the book. First, they came for the gun owners, which is why I'm talking a little bit about this now, because we're seeing these trends that I flagged in my book. First, they came for the gun owners. They continue on, and it's very important that you see these and understand these. Again, that is what 18 U.S.C. 922G is all about. It's a list of people that if you fall into those categories, you're just disarmed, including, if you're a felon, subject to these domestic violence restraining orders, which are just restraining orders, and so on, you are categorically denied your right to keep and bear arms, period, full stop, for the rest of your life, with the exception of domestic violence orders, which says that you are prevented from having guns during the duration of the restraining order while it's in place. Nevertheless, again, you can see here that wholesale level disarmament. And again, there's also this sort of individualized retail level disarmament, as they see it, which are like red flag laws, where there's a specific target on your back, an ex-girlfriend, an ex-boyfriend, an ex-spouse trying to get leverage over you for some reason, targets you and tries to take away your guns individually. I call the 922G stuff a wholesale version of disarmament at the wholesale level, where they just take guns from categories of people. That's to be distinguished from what I call the retail level disarmament, where you're specifically targeted one at a time. That's, again, an example of retail level. Wholesale level, retail level, these are important concepts to understand because they try to attack both. And when it comes to red flag laws, by the way, the idea that red flag laws are an additional way to disarm more Americans over and above those Americans disarmed under 18 U.S.C. 922G. But let us continue here. As you can see, these briefs that I'm talking about basically are justifying, as I see it, historical analogs to say that the wholesale disarmament is perfectly acceptable. The other thing we also see, and it's something called the Second Amendment Law Scholars Brief. They say that historical laws disarm those who refuse to swear an oath of allegiance. They were also include disarming enslaved people. They also involved disarming Native Americans, all of whom this occurred because they said the founding era legislatures deemed these groups to be a threat to public safety. Although, again, all of these briefs make references to these laws are odious, they're noxious. Nevertheless, the reality is they're all basically being embraced as historical analogs for the U.S. Supreme Court to consider to take away our rights. So let me just sum up what I think all this means. I think at the end of the day, the use of these laws against blacks, against Indians, against Catholics, against people with conscientious objectors, Quakers, pacifists, and the like, I think this demonstrates the depths to which some people in the gun control movement are willing to sink to make sure that our Second Amendment right to keep and bear arms is taken away from us and denied and shrunk or destroyed in its entirety. It's simply ridiculous to think, if you think about it, in no other context would people possibly consider invoking overtly racist and bigoted historical laws in support of taking away Americans' fundamental rights of any sort. Nevertheless, it seems to me there are certain folks out there and certain organizations out there that seem to be so desperate to take away our fundamental right to defend ourselves, our fundamental right to keep and bear arms, that they're willing to embrace and cite and actually put forth before the U.S. Supreme Court these racist, odious, noxious historical laws to justify their ultimate goal, which again is to shrink the scope of the protections we find in the Second Amendment. Moreover, it's also, of course, from the point of view that any of these people are liberals, and I mean progressive liberals, not classical liberals, also obviously modern-day progressive liberals. I also want to make an observation that to the extent some of these anti-gun organizations are progressive liberals, or at least they pretend to be, It would be a contradiction of at least their usual liberal platitudes that we've seen in the past by groups like the ACLU, because, for example, the ACLU is quoted as saying in their brief, "We need not build our history and tradition on repugnant laws that today would be struck down as unconstitutional." So even the ACLU is saying these laws are repugnant. They cannot possibly be the basis for anything to take away American rights today, because these would be unconstitutional and illegal today. If you passed a law saying we're going to take away guns from Catholics, it would be illegal. In fact, a couple years ago, you kind of had something very similar to that in the Espinoza case versus Montana. That's Espinoza versus Montana, which dealt with the use of public taxpayer money to go to charter schools and religious schools and things like that under a Montana program for education. That's right. The fact that you had 30 laws on the books in the late 19th century that were really anti-Catholic laws, the U.S. Supreme Court considered in Espinoza and basically said none of those can be justifiable histories when it comes to interpreting the First Amendment. Moreover, of course, the First Amendment was adopted at the same time the Second Amendment was in the year of our Lord 1791, and late 19th century precedent is simply not relevant to all of the above. And it's also, again, interesting that anti-Catholic precedent from the late 19th century was disposed of as not being relevant or helpful to interpreting the Second Amendment. So how exactly is anti-Catholic laws disarming Catholics going to be relevant to the Second Amendment when they'd be unconstitutional today? I think the answer is the Supreme Court is not going to consider any of those as persuasive historical analogs to take away our rights under the Second Amendment. To sum it really quickly, I think it's interesting that if any of these historical analogs that talk about the perception of dangerous, or these briefs that argue about the perception of dangerous war to be embraced, it seems quite easily to see how they could be weaponized against politically unfavored, disfavored, or political minority groups, such as, let's say, conservatives, or MAGA supporters, or Trump supporters, or whatever. Because if you can justify disarming entire groups of people that fall into categories of blacks, of slaves, of Native Americans, of Catholics, of Quakers, whatever, then that seems to suggest that you could categorize all sorts of politically disfavored groups as being a threat to the social order, a threat to the public. The perception is they're bad in some way, and therefore they can be disarmed. I don't think the U.S. Supreme Court in this Rahimi case is going to embrace these precedents, is going to embrace these historical analogs as being relevant to what's going on here. Nevertheless, it's very important for you to understand out there the lengths to which some of these people will go to take away our rights, the depths to which they will sink. It's very important that you understand that is what we are up against in many of these lawsuits, in many of these Second Amendment fights that we're in. And again, it's important that you know this, because if you don't know this, you're not going to be able to fight back and win for our fundamental rights and freedoms. Okay, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. Don't forget to follow me on Twitter at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.